sorry, Kevin Hulbert.
Thank you, Mr. Chair, and thank you, committee. What I'd like to address is really at the core of this bill. It's a red flag bill, but the red flag for me and the bill is the ex parte process itself. The crown jewel of American justice is the two-party court system, two parties contesting an open court in a fair proceeding. This ex parte procedure is being used to, frankly, just try to do too much. And I'm begging the legislators in Maryland not to begin to use ex parte proceedings to attempt to do what's being done in this bill, which is taking away the civil rights, the property, and possibly the liberty of someone before there's ever been a true judicial proceeding. The ex parte process here is only quasi-judicial. It involves briefly a judge at the beginning of the process. However, all the things that happen, the actions are taking place at the beginning, followed by the judicial process later. That's backwards. To me, it's frankly un-American. I did some research into the notion of ex parte justice, and what I discovered was that all ex parte proceedings demand the highest degree of honesty and candor because of the limited nature and the dangerousness of an ex parte proceeding in which only one party is present, and it's often done in secret. And for that reason, the ex parte proceedings require the full and fair disclosure of all facts adverse to the informant or the moving party. Now, the problem I have with this bill and also with HB 1263 is there's nothing in those bills that require the petitioner to do anything other than show up and claim to have a relationship with the respondent. They're not required to submit to this fair and full disclosure of any adverse facts that relate to them. So I'm asking for an unfavorable report and not to take the ex parte process any further down the road in Maryland. It's unjust. Thank you.
Can I ask you a question? I'm sorry, and I don't mean to belabor the point. I know it's late, but I just trying to get all these language right. How is that any different from? I mean, I do family law. Like, how is that any different? But for the fact of Senator Cassidy's questions before about the relationship of the parties, I mean, in an ex parte proceeding for domestic violence, I'm not required to come and give adverse facts to the judge. I come in there and I say why I'm in fear, and I say what happened, and I'm not required to do anything beyond that. How is that? I'm not sure I understand your distinction.
Well, I think it precisely illustrates what I'm driving at, which is almost every thinking adult is aware of the problems with the ex parte procedures in protective orders and in the domestic cases where the parties, one or the other, may attempt to maneuver out of revenge or for leverage in custody cases, in divorce cases, and frankly will lie in the proceedings. And Maryland does not seem interested in prosecuting perjury. So I've never heard anyone say that they're aware of any prosecution for perjury in Maryland, yet this problem is, I think, a big problem in the ex parte judicial world, where one party will lie, cause lots of problems, and it's unjust to the other party, and yet no one is punished for it, and it happens repeatedly, and there's no real prevention for it. So I guess, Mr. Chairman, I'm saying that I think a party who is leveling a serious charge against another person should not only reveal their relationship to them, but they should undergo an examination of just what the full relationship is that they have to the person that may reveal some adverse aspects of that relationship. I just don't believe that under the current system, I think it invites lying. Thank you.
Lynn House.